We'll go from there, okay?
By the look on this guy's face, you can tell he's like, oh, I done messed up. Hello, my friends. It's your favorite attorney, or maybe your second or third favorite attorney. I don't know, whichever one it is. It's attorney session at your service. And today I'm going to react to another video for you. I will be reacting to Code Blue Cam's child predator attempts to meet with minor, gets greeted by police officers, as well he should. As always, thank you for tuning in. Please subscribe if you haven't already subscribed to the channel. We're trying to grow this community. Please leave your comments on the video. And if you have any videos you would like me to react to, please let me know that as well. Thank you for tuning in, and thank you for checking out the video.
On July 6, 2021, an investigator posed as a 15-year-old girl on an anonymous social media platform and attracted the attention of a 29-year-old man, Ryan Burton. During the next few hours, Ryan had allegedly sent the investigator explicit photos. After the investigator admitted they were 15 years old, Ryan continued to pursue the contact. He eventually asked for a home address and agreed to meet later that day in La Crosse, Wisconsin.
You're at the front door now, in case you want to walk in.
Instead of a 15-year-old girl, he was greeted by officers and the undercover investigator he was actually messaging with.
How you doing, man? Good. Good. My name's Detective Ross, and I work for La Crosse Police Department. Can you take your hands out of your pockets for me? Yeah. What's your name, sir? Ryan. Ryan? Okay. Any weapons with you today? No. Okay. You just want to put your hands on top of your head. I'm just going to pat you down, make sure you got no weapons with you today. We're at the police department as well, sir. See our badge? Yes. Yeah. Okay, good.
You may be wondering, how can the cops just randomly come up to somebody and start patting them down? First, all a cop needs to detain an individual for questioning is reasonable suspicion. Reasonable suspicion is a lower bar than probable cause, which is needed to make an arrest or conduct a search. But you may be wondering, the cop is conducting a search right now. The cop is actually doing a pat down or a frisk. And if a cop has reasonable suspicion to detain someone for questioning, they can conduct a pat down or a frisk to make sure that the subject doesn't have any weapons or anything that might harm the cops for the cops' safety.
Are you okay? You haven't hurt, Brian? I'm good. Good. Just gonna check these things for fit. What's your last name, Brian? Ryan. It's in the middle compartment of my car. Can I go get your ID for you, please?
The cop asked for the subject's ID, and the subject told the cops it was in the middle console of his vehicle. That gives the cops consent or permission to look into the middle console of the vehicle to retrieve the ID. Anything else in plain sight from that point that the cops are able to see, they can use for evidence.
Let's just have a seat here on the step.
You may be noticing that the individual is in handcuffs and he's placed under arrest, but he hasn't been told he's under arrest. He hasn't been told any information at all. Do the cops have to tell you any information when they're arresting you? Do they have to tell you the reasonable suspicion they have for detaining you? Do they have to tell you the probable cause they have for arresting you? Technically, the cops don't have to tell you anything, and when you arrive to court, the judge will communicate this information to you. Now, there are many states and many police departments across the country that will require cops to inform citizens of the reasonable suspicion or the probable cause that they have to detain you or make an arrest, but there's nothing in the law that forces police officers to tell you this. They just have to have it to detain you for questioning, make an arrest, or search you.
To have a car come over and transport you back to the station, read you your Miranda rights, try to ask you a few questions, and we'll go from there, okay?
By the look on this guy's face, you can tell he's like, oh, I done messed up. But I would guess that this has been a pattern of his, if he is in fact guilty, and that this is not the first time he's done something like this. So he doesn't even look surprised at this point.
Hey Ryan, I'm Officer Howell, La Crosse Police. You have anything on you that's going to stick me or poke me, anything sharp? No. Can you step at your feet, please?
tall for that seat.
So you guys have, I mean, you guys saw him walk up to this door? You told me it was locked.
Was it locked? He obviously tried to get in. He had his head in the swivel.
Got through the alley.
Do you want anything to do with the car?
No, I called Grinky. He's like, he's separated from the car.
He was married with a car seat in the back seat. That is troubling. So now let's talk about this search that they are conducting of the vehicle. Can cops search your car? Let's start with the general rule that the Fourth Amendment of the Constitution protects you from unreasonable searches and seizures. This means that cops cannot search your person or your vehicle for evidence without first having probable cause to do so. And with probable cause, they need a search warrant unless an exception applies. One exception exists under probable cause where police can search your vehicle if there is probable cause to believe that the vehicle contains evidence of criminal activity. For example, if the police pull you over and your car interior smells like marijuana, they smell it coming from the vehicle, then they have the right to search the vehicle to look for marijuana. Now, I'm not sure what type of evidence of criminal activity these gentlemen may be looking for in the subject's vehicle at this point. They have him, they have his phone. I don't know, maybe some other documents that may show that the man was coming to the scene to meet an underage girl. I'm not sure. So that's kind of unclear to me.
You have that on any of the...
He sent one picture and it was from his neck down. He was naked.
Okay.
He was naked from his neck down. You know, I know this is I know there was an officer posing as a 15-year-old girl, but this kind of makes me sick to my stomach to know that individuals like this exist and that they are preying on underage girls. Okay, let me stop. I'm prosecuting this man before he was given due process of law, but it's not looking good nonetheless.
Both therapists mentioned that I had nonverbal cues that I was uncomfortable when talking about what happened. After some reflection, I think this is because I've always felt like I'm a good person, I'm kind, but this has turned me into a predator, and that makes me very uncomfortable.
Manifesto.
Why don't we just take that whole thing?
Okay.
I guess that's the evidence of criminal activity they had probable cause to believe was in the vehicle.
You ever been placed under arrest before?
Yes.
Interrogation room. Okay, let me first start by pointing out that there's an interrogation room. So usually when that happens, the cops are going to start asking you questions or interviewing you. But there's a problem. The man has not been Mirandized. He has not been read his rights. So having your Miranda rights read to you informs you of your Fifth Amendment right against self-incrimination. If you're read your Miranda rights, you will have the understanding that you do not have to talk to the cops, especially without a lawyer present. So how does he know if he's arrested? There's a lot of confusion going on. Miranda still can apply to your case if you're under custodial interrogation. Custodial meaning you are detained by the police and do not feel that you're free to leave. Obviously, this man is detained and does not feel that he's free to leave because he's in handcuffs sitting in a room and he can't go anywhere. Interrogation meaning the cops are questioning you to elicit a criminal response. They haven't questioned him yet, but if he's in an interrogation room, you would have to assume that he's about to be questioned. Whether or not you feel you're under arrest, if you're placed in handcuffs, detained, don't feel like you're free to leave, and the cops are questioning you to elicit a criminal response, just go ahead and assume that Miranda applies to your case and stop talking and ask for an attorney.
You can go ahead and sit down and relax.
He looks very relaxed, actually. He looks too relaxed under these conditions and this circumstance.
Water or anything? Alright. For a reason. I got an open investigation. I investigate crimes against kids.
Okay.
Alright. Does that ring a bell?
No.
Okay, you still have no idea why you're here? Okay. I'm going to read you your Miranda rights, okay?
I was just going to say, he's asking questions to elicit a criminal response. When you say I investigate crimes against children, does that ring a bell? If he says yes, then that would implicate him in this criminal activity. As I said before, stop talking.
I'd like to talk to you about why you're here, but obviously I can't talk to you without first protecting you.
Bingo! Read them as rights.
Ryan, before we ask any questions, you must understand your rights. You have the right to remain silent, and anything you say will be used against you in court of law. You have the right to talk to a lawyer for advice before we ask any questions, and to have him or her with you during questioning. If you're unable to hire a lawyer, you can request and receive appointment of a lawyer by the proper authority without cost or charge to you to be present and advise you before and during this statement. If you decide to answer questions now without a lawyer present, you will still have the right to stop answering at any time. You also have the right to stop answering at any time until you talk to a lawyer. As long as you understand your rights, Ryan, I need your signature here. And if you want to talk to me and talk to me about why you're here, signature here. Okay. So this is just that you understand your rights. This is if you want to talk to me. If you don't want to talk to me, you just tell me now. Okay. Don't want to talk? No. Okay.
Okay, now I'm not on this guy's side. I'm just going to blatantly put that out there. I'm not on this case, not privy to this case. I'm just reacting to it from an attorney standpoint. But good job on not talking to the cops. Wait until you have your attorney present or until you're advised by an attorney.
There'll be two charges. All right, one of them is the use of a computer to facilitate a child sex crime. Okay. And the second one is attempted second-degree sexual assault of a child. Okay. All right. So I'll respect your wishes, and we're going to get you out of here as soon as we can. Okay.
So when you hear about these sting operations, I often hear people in the community talking about entrapment, and the cops are actually setting up the criminal activity, making people do it, and it can't be legal. Well, let's discuss that for a brief second. What is entrapment? Entrapment occurs when a law enforcement officer or agent of the state acquired the evidence necessary to commence prosecution of an individual by inducing the individual to engage in criminal activity that the defendant would not otherwise have committed. So what that means is the defendant must not have a predisposition to committing that crime. Obviously, that's not the case here because the cop on the other side of the computer screen informed the individual that she was 15 years old and that person continued with the relationship, which is a sign that the individual wanted to engage in an inappropriate relationship with an underage girl. I also want to note that most state laws specifically state that merely providing an opportunity for a defendant to commit a crime does not constitute as entrapment.
Ryan faces felony counts of attempted second-degree sexual assault of a child and using a computer to facilitate a sex crime. Officers say screenshots show in less than 3 hours, Ryan went from sending an initial message to arriving at the doorstep. Burton is free on a signature bond that prohibits contact with his 2 biological children. The bond also permits that he has supervised contact with his stepchild and limits his access to the internet. He faces up to 60 years in prison if found guilty on both counts.
So that was rather a tough one, especially for me having a young daughter and knowing that individuals out there like this exist. However, we do need to address these issues when they occur. And we do need to discuss the legalities of what's going on surrounding criminal procedure when these individuals are taken into custody for various crimes. Thank you for tuning in. Remember, leave your comments. I love hearing your comments. I love reading them. I love interacting with you guys. And if you have not already subscribed to my page, please hit subscribe. Please hit the like button. Till next time, take it easy, my friends.